Well, thank you for joining us today. I'm Andy Hart from FEBC, and we're really pleased to be bringing you this webinar today in association with Public Trust. We've been working with the team from Public Trust for a while now and really appreciate their expertise as New Zealand's largest provider of wills and estate administration services. This webinar is part of a campaign that we're running to offer you a discount to make a will through Public Trust. Now, if you've only registered for this webinar today, don't worry, there's still time for you to take advantage of the discount offer, and we'll share some more information about that at the end of the webinar. FEBC stands for Far East Broadcasting Company, and we're an international association of Christian radio stations and media outlets that broadcast the message of God's love to literally millions of people around the world. FEBC operates throughout Asia, the Middle East, Africa, into Russia and parts of Eastern Europe as well. Our broadcasters are speaking to people who really need to hear the message of hope in Jesus Christ in closed countries like North Korea, in places that have been ravaged by earthquakes and floods, and in war zones too, like Ukraine. If you do feel led to leave a gift in your will to a charity, please do prayerfully consider FEBC so that your legacy can make a difference for generations to come. But you don't have to support FEBC to be on this webinar or to take advantage of the discounted will offer either. We believe it's a solid biblical principle to pass on a legacy to the next generation. And so we'd love to help all New Zealanders to be prepared by having a will in place. And that's a goal that we share with the Public Trust. And so now I'd like to hand over to Public Trust. I'd like to introduce Amar Imam, who's the Head of Partnerships for Public Trust, to introduce our presenter for today's webinar.
Thank you, Andy. I'll spend the next couple of minutes just talking about who Public Trust is, and then I'll throw over to Kimberly Rayner, who is a Senior Trustee, who's been with Public Trust for going on 9 years now, and deals with some of the examples that she is going to talk through about wills and EPAs and other services of Public Trust on a day-to-day basis. So we'll get to hear from her soon. She is a killer netball player, so if you do play netball, you want her on your side. So who is Public Trust? So Public Trust, many of you may not know, is celebrating its 150th year of operation in New Zealand, and it's quite a remarkable feat. We are a Crown-owned entity. Most people will know Public Trust for their wills, the enduring powers of attorney, and administering estates. But there are other arms to Public Trust which deal with conservatorship, so helping those that can't help themselves, vulnerable Kiwis or unstable, and trusts. We also have a large charitable trust where we help manage the money for charitable trusts. But we are here today to talk about wills and EPAs. Just a bit about how we go about providing services to New Zealanders and to be relevant and accessible. Last year, we helped roughly around 1,400 customers with managing their estate, so administering their estate. Quite a large number, and that number is rising off the back of COVID. 7,600 people to write a will, 2,000 that have written an EPA, and about $600 million in distributions and bequests to 7,000 plus beneficiaries. And that includes charitable organisations like FEBC. So those people that have left a bequest in their wills, we do work directly with those charities to get the money distributed. That's enough from me. I think that gives you a good idea of who Public Trust is. We're celebrating 150th year and looking to continue on for another 150 years. But I'll throw it over to the lovely Kimberly to take you through why we're here, which is wills and EPAs.
Cool. Thanks, Amar. Hi, everyone. Thanks for coming along and listening to what I've got to say. So I'll just be talking to the slides a little bit and hopefully answering questions with what I've got to say throughout, but obviously there's a possibility for Q&A at the end as well. So you can either pop your questions in the chat or save them to the end. So your life, your legacy, basically the main question when we're thinking about estate planning or things like that is how would you like to see the life that you've built be left behind? And this is, the main question we want to think about if you come in and do your will with us, or if you did your will on our online platform. How would you like your estate to be left, and who would you like it to go to? So when I first started with Public Trust 9 years ago, when I heard the word estate, I thought it meant a large house or a mansion or something like that. But an estate is so much more than just your house. It's everything that you've created, everything that you own, everything that you owe. So it's really important to make sure that you have set out everything that you have to make sure it goes to who you want it to go, and your legacy lives on basically after you die. So your will is your foundation document of your estate planning needs. And that's the main thing we look at when we're talking about planning your estate. So there can quite often be negative thoughts or feelings or emotions around estate planning, or when it comes to thinking about have you written your will. For me, it's such a everyday thing. I think about it all the time, obviously, because I come to work and do it, but I do understand that it can be a sensitive topic for customers or people that are not used to discussing when you die. So we're very aware that it is a sensitive and emotional time for people. So we're here to offer our expertise and give you some guidance as well along the way to make sure that your legacy is continues after you're gone. So if it's important, say it with a will. So basically that speaks for itself, that anything that you have in your life, if it's important enough for you now, it's important enough to make sure that it is looked after you're gone. So that's obviously assets. It's also liabilities though. So it's about making sure that your debts are paid and things like that, but also the things that you have now go to the correct people. There's also the meaning of having an estate to administer is basically saying that you've got to have $15,000 in assets in your sole name for there to be an estate to administer. So if you do have less than $15,000 in your sole name when you die, your executor wouldn't administer your estate. It would just be up to your next of kin or somebody to. We call it informal administration. So $15,000 in your sole name is an estate, and that is when we need to start looking to get things like probate from the High Court. And probate is the permission from the High Court for your named executor in your will to be able to legally administer your estate. And that means uplift your assets and pay your liabilities, distribute your estate as you've put in your will. I have noticed that there is quite a stigma with New Zealanders and like just the Kiwi way that you don't need a will unless you've got a house or kids. That's not really the case anymore, because we've got the KiwiSaver retirement plan now, which is compulsory for employees. 9 times out of 10, when you die, you are going to have $15,000 or more in your sole name, and KiwiSavers have to be in sole name, so it's not going to pass to a joint holder or anything like that. So that kind of emphasises the importance again to have a will. So if you only have a KiwiSaver, for example, and it's over $15,000, you still want to make sure that that goes to the person or the people that you want it to go to and you intend it to go to. Just going back to joint assets, anything you do own with a joint account holder or an asset that you own jointly with somebody, it does pass to that joint survivor, and there's no need for it to be part of your estate. But anything in your sole name, like a KiwiSaver, if you have a house in your sole name, even if you own a house, tenants in common, anything like that, shares, stocks, bank accounts and sole names, everything like that falls under your estate, and that has to be administered by your will and your executor. It's just mainly a chance for you to recognise the people that are left behind. So I mentioned the word executor a couple of times in that previous slide. So if you aren't sure what an executor is, basically it says here, the executor has the important task of carrying out the instructions in your will and ensuring your legacy lives on. So the executor is the person at the top of your will, basically in charge of administering your estate, and it can be a outside executor like a loved one, a friend, a family, a relative of some sort, but it can also be public trust. So the majority of the wills that we do here at Public Trust, if people come to see us to write their wills, they more often than not would appoint Public Trust their executor. And that's mainly because, as Amar mentioned, we've been around for 150 years this year, so we're a trusted trustee corporation. We literally do it day in, day out, so we know what we're doing, we've got the expertise. And another main reason people appoint us to be their executor is because we've got the impartiality, which is really important, especially in estate situations where you might not have a smooth sailing family, or your estate or your will might not be standard or simple. So it's very important to have somebody like Public Trust to be able to manage the tricky side of things. We do have a lot of estates now where it's not a standard arrangement. I mean, when we say standard, we'd usually say everything onto your spouse and then onto the kids equally, no blended family, no issues. That's what we would say is a nice and easy estate, but they're very rare these days. You guys would know that blended families are more and more common these days, so that's quite always a more difficult estate to administer if there's any issues there. If you've got a business, if you've got multiple properties, if you've got overseas assets, they're all important or more tricky things to administer in an estate. So appointing Public Trust is probably a really good idea in that case. The other thing about appointing Public Trust as your executor rather than a person, a loved one or an external executor, is that we don't have that emotional connection to the family, and we don't have any bias or we're removed from the situation, so we are able to make decisions impartially and without any judgment. So it is good to appoint us in that regard. If you do have a standard straightforward situation where you've got no issues, you're more than welcome to obviously appoint a friend or a family or a loved one. The only thing we do say is if you are appointing a personal executor, so not a trustee corporation like us, you should discuss the appointment of the executor role with them before putting them in your will, because there is a lot involved in administering an estate. And obviously, if you are quite close to the person that has died, there is always a lot of grief and feelings going around there that it is not an easy role. So as long as that outside executor understands what responsibilities they have as executor, and if they're going to be emotionally available for that role, then that's fine. There are some estates that are wound up within 6 months, and then there are estates that are going 4+ years. I've just actually wound up an estate that the man died in 2018, October 2018, and I only just finished the estate administration last month. So that's pretty amazing. It's the longest one I've done, but it was a tricky one. So going on to if you don't have a will. So if you die and you don't have a will, but you do have assets of $15,000 or more, it's called dying intestate, or you have an intestacy. And that, means you don't have a will, but you do have assets that require administration. In that situation, whoever is going to administer your estate, whether it's a family member or a next of kin, or whether it's us, you have to go through the court to be able to get permission to do this. And although that sounds like probate, which we have to do anyway, it's completely different. It's very time consuming and very expensive to have to go through the court to administer or get permission to administer somebody's estate that hasn't got a will, because the assets left behind are administered under the Administration Act 1969, and they basically have a tier or a matrix of who will receive your estates, your assets in your estate. So it might say it goes to this person, and if this person doesn't exist, it goes to these people, and then vice, down the chain. So there's many situations where family members don't want their assets to go to who should have it. So, for example, to a wife or to the children or to grandchildren, there might be a reason in that person's life that those people shouldn't receive the estate. But if you don't have a will to explain why, then the Administration Act will come in and those people will get it as per the court direction. An example I do have is a will I did for a man at the end of last year, and he gave me his will instructions, and he died before he could sign his will because the turnaround was so short. He didn't have his affairs in order before he got terminally ill. So he advised that he wanted everything in his estate to go to his neighbour because they had a very strong bond and he had no relationship with his family for so many years. But unfortunately, because he died without signing his will and he didn't leave enough time, the people that are able to inherit under his estate are his family. So I know for a fact they weren't his wishes, but because we didn't get the will signed in time, his will would become an intestacy. So yeah, it's a lot more expensive to not have a will than, you know, just pay the cost now and get it done. Writing a will with public trust. So we have the online platform PT Online, which is Public Trust Online, and you can do your own will. This is quite a new platform for us, but it's pretty amazing. So you can pop online and at a fraction of the price, you can do it yourself. So we do have different tiers of complexities that you can do online. So from very basic up to more complex. And you can choose what situation suits you best, and obviously the price is dependent, but it starts as little as $99. And we've got online reps and everything available through that online portal that can help you write your will. So even if it's just getting something standard or basic together, it's really important that you do that. The other option is obviously you can come into one of our branches, which are dotted all around the country, and we can, write your will with you face to face if you want some more personal experience, or you've got more of a complex situation that requires more than what the online portal could offer you. We then store your will here if you've signed it and done it with us in branch, and it's always available for you to get a copy of and things like that. So big decisions while you're living. This bit I'm going to talk about next, just for the next 5 minutes, is enduring power of attorney documents. So moving on from wills, we're now going to talk about enduring power of attorney. So the will looks after things when you die, and enduring power of attorney documents looks after things while you're living. So there are two types of enduring power of attorney documents. There is the EPA for personal care and welfare, and there is an EPA for property and financial assets. So they are two separate individual documents. You don't have to have them both. You can have one, but it's always recommended to have both. The reason we need to have these EPA documents in place is that if you ever need help while you're living, but you don't have the capacity to be able to make the decisions yourself, you need to appoint somebody or people to look after things, your assets or your welfare, while you're still alive. So people again have misconceptions with EPAs that you need to be very old to be able to get them, or don't worry about them until you're old. But that's, we definitely say don't wait until you're too old to do them, because anything can happen to you prior to that, touch wood. But also you don't want to wait till you're too old and you maybe don't have capacity to do the documents anymore, and then who's looking after your things. So also with an enduring power of attorney document, just because you're married or have a spouse or all your assets are in joint names, such as bank accounts and a house, it doesn't mean that that spouse or joint account holder can look after things if you lose your capacity. The thing is, if you need to sell your house and it's jointly owned, you can't sign on behalf of the joint account holder or the joint holder of the house. They need to sign themselves. You can only sign on their behalf if you're their enduring power of attorney. Same if you want to deal with the IRD or electricity companies or WINS, anything like that, you need to have the EPA document in place and be appointed their attorney to be able to act for them. So the two main EPAs are personal care and welfare and property and finances. You can appoint Public Trust to be your attorney for property and finances if you need us to. That's something that we deal with every day as well, similar to estate administration. We deal with our clients who cannot look after their own property and finances, or don't have any friends or loved ones, family that can do it for them. So that is something we're quite happy to do. That's called our personal assist service, or our triple PR service, which is where we help our vulnerable people to look after their finances. We can't unfortunately be a personal care and welfare attorney, as we don't have that understanding or emotional connection to the client at that point, but you can appoint somebody that you trust and that you would want to carry out the decisions and things as you would do yourself. That's always what I say to somebody when you think about who you should appoint. So that's pretty much EPAs in a nutshell. And there's a little video here, but I'm not going to play it because the sound wasn't working. But yeah, you can create your will online with Public Trust, as I mentioned. But that's pretty much it from me. And if we want to go back to you, Amar.
Thanks. Thank you, Kim. There were some questions that were sent through beforehand that I'll just fire away at you, Kim, to answer. You may have already covered these, but we'll just go over through them again. That'll also give the opportunity to the guests that are online to note down any questions they may have, and then we'll open up to the group to ask any individual questions they may have. You covered this, but if you wanted to cover it again, do I have enough assets to make a will, and what happens if I don't have a will?
Yep, so just if you think about $15,000, that's the minimum assets you need in your sole name for there to be an estate to administer. So anything $15,000 and over, your spouse or your next of kin won't be able to administer those on your behalf if you don't have a will. So that's basically the key amount. If you've got 15,000 or more, please get a will, so it's easier for whoever needs to administer your estate when you die to be able to do that.
Thanks, Kim. How important is it to name an executor, and does it have to be public trust?
Yeah, so you have to name an executor in a will. It's the main role of having a will and the main person that will administer your estate after you go. It doesn't have to be public trust, as mentioned. We offer obviously pros of being the executor, such as impartiality and expertise and things like that, but obviously there are pros of having an outside executor as well, such as less cost, because public trust do charge fees for our time, but it just depends what your situation is and what you want to do for your own particular circumstance.
Thank you. I might answer this one. What does it cost to make a will with public trust? Well, there are two modes for you to write a will, as Kimberly pointed out. One is through our online platform, which is a self-service function, which is cheaper if you want to go through it and follow the bouncing ball online and do it yourself. And then there's our in-centre in-person will creation. As you can see, there's approximately 20 odd offices that you can go into and have an in-person meeting, and that is slightly higher. Now, with the offer with FEBC, it's best to get in contact with FEBC to see what the offers are and what you qualify for. But they are kindly offering a contribution towards getting a will completed through FEBC. So please do get in touch with them. Next question for you, Kim, is public trust able to execute complicated wills? And I'd be really interested to hear an example of a complicated will that you've seen as well.
Yeah, yes, we can do from standard to complex. So something that we would probably consider complicated would be anything with overseas assets, such as bank accounts or shares or properties. Any estate that has more than one property, so investment properties or anything like that. An estate that has a trust would be complicated or more complex, or an estate that the deceased owned a business or was a director or something of a business. They're all estates we would consider more complicated, but in saying that, we still deal with them on a daily basis. So it may be more in the complex realm and a bit too tricky perhaps for an outside executor to do, but yeah, we still deal with those on a daily basis. We do encourage, if you have overseas assets, that especially in a non-Commonwealth country, that you have your own separate will in that country covering the overseas assets. So for example, we do administer assets in countries such as Australia and the UK. UK is still quite tricky. We can do it, but Australia is relatively easy because they're so similar to us in many ways. But yeah, if you do have assets overseas, we do say, please try and get a will in that country that governs those assets, so your New Zealand will can cover your New Zealand assets.
Thanks, Kim. It's also important to revisit your will when significant events happen in life. I was speaking to a couple on the weekend, and they're both remarried to each other, but they haven't updated the wills. So their previous partners or husbands or wives are still included.
Yeah, that's actually a good
tricky.
point, Emma, because once you're married, if you do your will prior to marriage or when you're married to somebody else, when you do get married, your other will becomes null and void. So yeah, if you do your will and you're not married and you don't make the will in contemplation of this particular marriage, that as soon as you're married, your previous will becomes not relevant, so you have to update your will. So for those two people, their new marriages take precedent because I assume they're divorced, otherwise that would be strange. And then you would need to update your will to ensure that legally that spouse is entitled to your estate.
Thank you. The next one, on average, does public trust take significantly longer than others to execute a will?
I don't have specific figures or facts to be able to answer that specifically, but I think we are pretty much on par because there are certain things that public trusts have to do that are in line with solicitors. So we have to apply for probate. So that is out of our hands. So once it's with the High Court, it's going to take the same amount of time whether public trust are administering your estate or a outside executor or solicitors doing your estate. Those types of things are out of our control. So the timeframes would be the same, but apart from that, I think we're very efficient in what we do and we move things along as quickly as we can. There's always factors that implement an estate administration that are often outside of our control, such as the High Court or Inland Revenue or selling a property or any disputes or contentious issues with beneficiaries or anything like that can hinder or delay an estate, such as overseas assets and things as well.
It's a great point. There are external influences that do dictate the time sometimes, but as the number stated earlier, we are well experienced in this area in administering estates on a year-on-year basis. So we feel that we're as efficient as we can be.
Yeah.
And this one may be for you, or the next couple may be for you, Andy. Question is, what percentage of charities charge interest on a gift that is given in a will?
Well, I was hoping that you guys might be able to give some insight into that one. I can answer there's another question that comes after that, and that is, does FEBC charge interest on a gift in a will? And the answer to that is no, definitely not. So, and I'm assuming that the thought behind that is, if the will hasn't been sorted and distributed within a certain time frame and the money is kind of sitting in limbo somewhere, or the person's estate is sitting in limbo, does the recipient or beneficiary, if I'm using the right terminology there, in this case FEBC, do we charge interest on that? It's certainly not been our experience in the past, and we don't have any intention of doing that in the future. As to whether other organisations might do that, I don't know. Do the people at Public Trust have any insight into that?
No, I haven't ever experienced interest being charged by charities. I think from my experience, charities are just so grateful to have been left a gift or a bequest or part of a residue of an estate that they're basically happy to wait for as long as it takes because, they're just grateful they've been recognised.
Yeah, I thought that would probably be the case too.
Yeah. I would be quite shocked if I then received a bill from that charity saying you owe us this much interest on top of the bequest. I've never received that before.
Yes, yeah.
Yeah, look, I haven't seen it either, but we will circle back with an answer. I doubt there is. We might open up to the floor for any other questions. Now, do we have the function, Felix, to open up the mic?
Yes, I can open mics up, or we can just do it through the chat function.
Chat function. Now, for those that are on a computer, you will see on your screen up the top, there are a bunch of icons. There is one that says chat. If you do have any questions, please click on that chat function, and you are able to type in your question that we will get answered for you online. So we'll give it a couple of minutes to see if there are any takers.
Does Public Trust ever decline the request to administer a will or estate? Yes, we do have situations, they are rare, that it wouldn't be valuable or giving value to the customers, the beneficiaries, if we administered the estate. I can't think of a specific example off the top of my head, but basically every time we go to take on an estate, we have a form and a spreadsheet that we complete to make sure that we are going to be adding value by administering the estate. So there is the option in the rare occasion that it wouldn't be in the beneficiary's best interest or even Public Trust's best interest to take on that estate for whatever reason. But again, it is quite rare. It might be that it's a very, very small estate, such as over 15,000, but maybe it's only 16,000. And there are sometimes instances we can step away from being executor to those because we're going to, it's going to cost too much to the estate to make it worthwhile or something like that. Or again, it may be that the estate might be better administered elsewhere. So yeah, we can decline, but it is rare.
Thank you. I'll just give it a couple more minutes for any other questions that may pop up. Oh, thank you, Josh. My mother-in-law died in 2002, and the Salvation Army charged interest on the gift that she left to them. We were horrified, but they were legally entitled to do so. At that time, the Salvation Army lost 10 would-be life donors.
That's
Okay.
crazy. I didn't know that, and I've never experienced that myself. So that's really interesting to know.
Good to hear that if EPAs doesn't.
Yeah.
I have a question I might throw in there.
Yeah.
Is there, if FEBC, if Public Trust has been appointed as the executor of the will, is there a cap on the amount of on the cost, the charges that Public Trust would charge?
Yeah, so we charge at a time and attendance basis, so mostly just at an hourly rate, but we do have some set fees that are across all estates. We do have a cap of 5% basically of the estate value, and that's for like our normal fees. So that's just for dealing with assets and liabilities that are within the realms of standard or normal estate administration. So the 5% cap doesn't apply to special things such as overseas assets or property dealings or tax, those kind of things. Anything that's outside the normal realm of a estate administration or a special cost is not included in that 5% cap, but otherwise, yes, we are we have to be within a 5% of the total estate value.
I might add to that. Most people will not be aware that we have our own Public Trust Act, which was put in place for New Zealanders, and that was for the reason to be the trustee of last resort. So what that means is there are other organisations or solicitors that can decline to administer an estate for whatever reason. Because we are a Crown entity and it was to Public Trust was set up to benefit New Zealanders, there are instances where we will administer the estate when no one else wants to. And the cap is in the Public Trust Act because we were set up for New Zealanders. Other solicitors or estate administration agents don't have a cap on their fees, and that was really to protect lower value estates.
We do have something called a straightforward estate administration option as well, and that is for estates that are between 15,000 and 120,000. And that is more of a set fee or a percentage based on what the asset value is. So those would be considered, you know, just a couple of bank accounts, or just a bank account in a KiwiSaver or something that is going to be under 120,000. So in most cases, it doesn't include a property or anything like that. And that way we have a specific cap of how much we can charge a straightforward estate, either a set fee or a percentage of that estate as well, which is less than 5%.
I can see Sebastian, who is our resident charities guru, typing, so I'm sure he'll have a response about a question around the charities front. In the meantime, if there are any other questions, please feel free to type them in. Okay, on the Salvation Army point, this is from Sebastian, who's our charities guru. On the Salvation Army point, I've worked with charities and charitable trusts for many years and have never heard of a charity charging interest and don't understand what the legal basis was for Salvation Army doing so. Thank you, Sebastian. And he should know he's been an expert in that area for a while.
It's good that that's not the norm then.
Yeah. I haven't seen any other questions come through, so if in the meantime, while I'm speaking, something does, we'll answer it. But if you just need a bit of time to think and digest the information that was provided today, please feel free to get in touch with Andy at FEBC or call 0800 433 226 with any of your questions. He can collate them and we can answer those and have it part of a frequently asked questions sheet that Andy can then distribute to all people that were in attendance. Thank you for your time, Andy. I'll throw it over back to you.
Yeah, thank you. Thank you to our presenters. Really appreciate the wisdom and experience that you've given us today. And as I said at the beginning, we really appreciated working with you guys and look forward to continuing to do so in the future. Thank you for joining us today, and don't forget that offer of a discount on making a will with Public Trust. If you would like more information about that offer, there's still time to put your email address in the chat window here, or visit our website at febc.nz, and we'll be happy to help you out there. Thanks again to our presenters today, and enjoy the rest of your day.
Thank you.
Thank you.
See ya.
Thank you, everyone.
Bye.
Thank you. Bye.